Hello dear friends, today we are continuing chapter 1 of Economic, Business and Commercial Laws from page 9. The topic is Regulation and Supervision of Cooperative Banks. Regulation and supervision of urban cooperative banks is another area the RBI has been entrusted with. In terms of Article 246 of the Constitution of India, the exercise of legislative powers of the Union and the State are given in the Union list and the State list, that is List 1 and 2 respectively, of the 7th schedule to the Constitution. The entry relating to cooperative societies fall in State list, whereas the entry relating to banking falls in the Union list. These results in the duality of jurisdiction over cooperative banks both by the Reserve Bank of India in terms of Banking Regulation Act 1949 and the Registrar of Cooperative Societies in terms of the respective State Cooperative Societies Act of the state concerned. Section 56 of the BR Act 1949 makes it applicable to cooperative societies involved in the business of banking. As a part of the regulatory and supervisory regime over cooperative banks, the RBI has been entrusted with the powers to issue licenses and cancel licenses of cooperative banks, supersede their boards, inspect them, and also issue directions to them in the public interest of banking policy, control over loans and advances, etc. In Janata Sahakari Bank Limited versus State of Maharashtra, Honorable Bombay High Court has held that through the control over management of cooperative society, where it is cooperative banking society or otherwise, is vested in the Registrar of Cooperative Societies, but insofar as banking is concerned, by virtue of Section 56 of the Banking Regulation Act 1949, read with Section 35A of the Banking Regulation Act 1949, it will be a subject with which the Reserve Bank of India has full power. Regulation of derivatives and money market instruments. Chapter 3D was inserted in the RBI Act with effect from 9th January 2007 by way of an amendment to the RBI Act 1934. In the said chapter, the Parliament of India thought it appropriate to introduce provisions relating to regulation of transactions relating to derivatives, money market instruments, securities, etc. by the RBI. Subsection A of Section 45U of RBI Act defines derivatives as an instrument to be settled at a future rate, whose value is derived from change in interest rate, foreign exchange rate, credit rating or credit index, price of securities, also called as underlying, or a combination of more than one of them, and includes interest options, foreign currency rupee options, or such other instruments as may be specified by the RBI from time to time. Similarly, money market instruments have been defined to include call or notice money, term money, repo, reverse repo, certificate of deposit, commercial paper, and such other debt instruments of original or initial maturity up to 1 year as the RBI may specify from time to time. The powers of RBI to regulate money market instruments have been provided under Section 45W of the RBI Act, which states that the RBI may specify from time to time in public interest or to regulate the financial system of the country to its advantage, determine the policy relating to interest rates or interest rate products and give directions in that behalf to all agencies or any of them dealing in securities, money market instruments, foreign exchange, derivatives or other instruments of like nature. Payment and settlement functions. The Parliament of India enacted the Payment and Settlement Systems Act 2007, PSS Act 2007, with an objective to provide for the regulation and supervision of payment systems in India and to designate Reserve Bank of India as the authority for that purpose and for matters connected therewith or incidental thereto. Under Section 4 of the PSS Act 2007, no person shall commence or operate a payment system except with an authorization issued by the RBI. Similarly, under Section 8 of the PSS Act 2007, RBI has the powers to revoke the authorization granted to any person if it contravenes any of the provisions of the PSS Act or does not comply with the regulations or fails to comply with the orders or directions issued by the RBI or operates a payment system contrary to the conditions subject to which the authorization was issued. The regulation and supervision of payment systems has been conferred on the RBI by virtue of the provisions of Chapter 4 of PSS Act 2007. The regulatory and supervisory controls include the power to determine standards for the functioning of payment systems, power to call for returns, documents or other information, power to enter and inspect payment systems, power to carry out audit and inspections, power to issue directions, etc. Consumer protection functions. In India, although the provisions of the BR Act 1949 requires the RBI to bear in mind the vital issue of protection of depositors' interest while granting a banking license or cancellation thereof, giving directions on advances on any banking matter, applying for suspension, winding up or amalgamation of banks, approving appointment of CEOs or additional directors, removal of CEOs, etc. There is no specific provision under the BR Act 1949 or any of the other statutes for forming a formal mechanism for redressal of grievances of depositors. In the absence of a specific provisions for the purpose, RBI has resorted to its powers under Section 35A of the BR Act 1949 to formulate the Banking Ombudsman Scheme for the redressal of grievances of depositors. Financial inclusion and development functions. The mushrooming of unauthorized and unregulated money lenders in the financial system of the country necessitated the RBI to do something more than what has been provided in the rule books. Financial literacy or financial inclusion, though not explicitly expressed in the RBI Act 1934 or the BR Act 1949, Subsection 16 of Section 17 of the RBI Act 1934 enables RBI to do all such matters and things as may be incidental to or consequential to the exercise of its powers or the discharge of its duties under the Act. Further, India being a country with significant illiteracy, there remains an obligation on the part of the state to educate the people and also to include them into the organized financial system of the country to get the benefits of professional banking system of the country. The amendment to the BR Act 1949, inserting Section 26A, is a step towards achieving this objective, which makes it amply clear that the statute casts a responsibility on the RBI to focus towards achieving financial literacy in the country. Not only the BR Act 1949, even the RBI Act 1934 mandates the RBI to maintain expert staff to study various aspects of rural credit and development, which emphasizes the premier role to be played by the RBI in promoting financial literacy and financial inclusion among the citizens living even in the remote areas of the country. Right to issue banknotes. Management of currency is one of the core central banking functions of the Reserve Bank, for which it derives the necessary statutory powers from Section 22 of the RBI Act 1934. Along with the Government of India, the Reserve Bank is responsible for the design, production and overall management of the nation's currency with the goal of ensuring an adequate supply of clean and genuine notes. In consultation with the government, the Reserve Bank routinely addresses security issues and targets ways to enhance security features to reduce the risk of counterfeiting or forgery of currency notes. The Paper Currency Act of 1861 conferred upon the Government of India the monopoly of issuing note, thus ending the practice of private and presidency banks issuing currency. Between 1861 and 1935, the Government of India managed the issue of paper currency. In 1935, when the Reserve Bank began operations, it took over the function of note issue from the Office of the Controller of Currency, Government of India. Denomination of Nodes. The Indian currency is called the Indian rupee, abbreviated as RE in singular and RS in plural, and its sub-denominations the paisa, plural paise. At present, notes in India are issued in the denomination of 5, 10, 20, 50, 100, 200, 500 and 2000. The printing of 1 rupees and 2 rupees denomination has been discontinued. However, notes in these denominations issued earlier are still valid and in circulation. The Reserve Bank is also authorized to issue notes in the denominations of 5,000 rupees and 10,000 rupees or any other denomination but not exceeding 10,000 rupees that the central government may specify. Thus, in terms of Section 24 of RBI Act 1934, notes in denominations higher than 10,000 rupees cannot be issued. The central government may, on the recommendation of the central board, direct the non-issue or the discontinuance of issue of banknotes of such denomination values as it may specify in this behalf. The Government of India announced the demonetization of 500 rupees and 1000 rupees banknotes with effect from midnight of November 8, 2016, making these notes invalid. A newly redesigned series of 500 rupees banknote in addition to a new denomination of 2000 rupees banknote is in circulation since 10th November 2016. Form of banknotes. The Department of Currency Management makes recommendations on design of banknotes to the central government, forecasts the demand for notes, and ensures smooth distribution of notes and coin throughout the country. That is Section 25. It arranges to withdraw unfit notes, administers the provisions of the RBI, that is Note Refund Rules 2009. These rules deals with the payment of value of the soiled and mutilated notes and reviews or rationalizes the work systems and procedures at the issue offices on an ongoing basis. Legal tender character of notes. Section 24, Subsection 1 of the Act states that, subject to the provisions of Subsection 2, every banknote shall be legal tender at any place in India in payment or on account for the amount expressed therein and shall be guaranteed by the central government. Subsection 2 empowers the central government on recommendation of the central board by notification in the Gazette of India to declare that, with effect from such date as may be specified in the notification, any series of banknotes of any denomination to cease to be legal tender, save at such office or agency of the bank and to such extent as may be specified in the notification. Currency distribution. The Government of India, on advice of the Reserve Bank, decides on various denominations of the notes to be printed. The Reserve Bank coordinates with the government in designing the banknotes, including their security features. The printed notes receiving from printing press set by the government and the RBI are issued for circulation both through remittances to banks as also the Reserve Bank counters. Coin distribution. The Indian Coinage Act 1906 governs the minting of rupee coins, including small coins of the value of less than 1 rupee. Coins are legal tender in India for unlimited amounts. 50 paisa coins are legal tender for any sum not exceeding 10 rupees and smaller coins for any sum not exceeding 1 rupee. The Reserve Bank acts as an agent of the central government for distribution, issue and handling of the coins and for withdrawing and remitting them back to government as may be necessary. Combating counterfeiting. The Reserve Bank, in consultation with the Government of India, periodically reviews and upgrades the security features of the banknotes to deter counterfeiting. It also shares information with various law enforcement agencies to address the issue of counterfeiting. It has also issued detailed guidelines to banks and government treasury offices on how to detect and impound counterfeit notes. Bank exempt from stamp duty on banknotes. The bank is not liable to the payment of any stamp duty under the Indian Stamp Act 1899 in respect of banknotes issued by it. That is Section 29. Powers of central government to supersede central board. Subsection 1 of section 30 of the state that if it is in the opinion of central government the bank fails to carry out any of the obligations imposed on it by or under the act by notification in the Gazette of India, declare the central government to be superseded and thereafter the general superintendence and direction of the affairs of the bank shall be entrusted to such agencies as the central government may determine, and such agency may exercise the powers and do all acts and things which may be exercised or done by the central board under the act. As per subsection 2 of this section, when action is taken under this section, the central government shall cause a full report of the circumstances leading to such action and of the action taken to be laid before the Parliament at the earliest possible opportunity, and in case within 3 months from the issue of the notification superseding the board. Issue of demand bills and notes. Subsection 1 of section 31 of the states that no person in India other than the bank or as expressly authorized by the act, the central government shall draw, accept, make or issue any bill of exchange, hundi, promissory note or engagement for the payment of money payable to bearer on demand, or borrow, owe or take away any sum or sums of money on the bills, hundis or notes payable to bearer on demand of any such person. However, checks or drafts including hundis payable to bearer on demand or otherwise may be drawn on a person's account with a banker, shroff or agent. As per subsection 2 of this section, notwithstanding anything contained in the Negotiable Instruments Act 1881, no person in India other than the bank or as expressly authorized by the act, the central government shall make or issue any promissory note expressed to be payable to the bearer of the instrument. Banker to the central government and state governments. Reserve Bank acts as banker to all the state governments in India. As a banker to the government, the Reserve Bank receives and pays money on behalf of the various government departments. The Reserve Bank also undertakes to float loans and manage them on behalf of the governments. It also provides ways and means advances or short-term interest-bearing advance to the governments to meet the temporary mismatches in their respective receipts and payments. Besides, it arranges for investments of surplus cash balances of the governments as a portfolio manager. The Reserve Bank also acts as an advisor to government whenever called upon to do so on monetary and banking related matters. The banking functions for the government are carried out by the Public Accounts Department at the offices or branches of the Reserve Bank, while management of public debt including flotation of new loans is done at the Public Debt Office at the offices or branches of the Reserve Bank and by the Internal Debt Management Department at the Central Office. Management of public debt. The Reserve Bank manages the public debt and issues new loans on behalf of the central and state governments. It involves issues and retirements of rupee loans, interest payment on the loan and operational matters about debt certificates and their registrations. The union budget decides the annual borrowing needs of the central government. Parameters such as interest rates, timing and manner of raising loans are influenced by the state of liquidity and the expectations of the market. The Reserve Bank's debt management policy the Reserve Bank's debt management policy aims at minimizing the cost of borrowing, reducing the rollover risk, smoothening the maturity structure of debt, and imposing depth and liquidity of government securities markets by developing an active secondary market. Reserve Bank as banker to banks. The Reserve Bank, to fulfill this function, opens current accounts of banks with itself, enabling these banks to maintain cash reserves as well as to carry out interbank transactions through these accounts. Interbank accounts can also be settled by transfer of money through electronic fund transfer systems such as the real-time gross settlement system, that is the RTGS. In addition, the Reserve Bank has also introduced the Centralized Fund Management System, that is CFMS, to facilitate centralized funds enquiry and transfer of funds across Deposit Accounts Department, that is DAD. This helps bank in their fund management as they can access information on their balances maintained across different DADs from a single location. As banker to banks, the Reserve Bank provides short-term loans and advances to select banks when necessary to facilitate lending to specific sectors and for specific purposes. These loans are provided against promissory notes and other collateral given by the banks. The Reserve Bank also acts as the lender of last resort. It can come to the rescue of a bank that is solvent but faces temporary liquidity problems by supplying it with much needed liquidity when no one else is willing to extend credit to the bank. The Reserve Bank extends this facility to protect the interest of the depositors of the bank and to prevent possible failure of a bank, which in turn may also affect other banks and institutions and can have an adverse impact on the financial stability and thus on the economy. Financial regulation and supervision. The Reserve Bank's regulatory and supervisory domain extends not only to the Indian banking system but also to the development financial institutions, that is DFIs, non-banking financial companies, that is NBFCs, primary dealers, credit information companies, and select segments of the financial markets. As the regulator and the supervisor of the banking system, the Reserve Bank has a crucial role to play in ensuring the system's safety and soundness on an ongoing basis. The objective of this function is to protect the interest of depositors through an effective prudential regulatory framework for orderly development and conduct of banking operations and to maintain overall financial stability through various policy measures. Prudential norms for banks. In order to strengthen the balance sheets of banks, the Reserve Bank has been prescribing appropriate prudential norms for them in regard to income recognition, asset classification and provisioning, capital adequacy, investments portfolio and capital market exposures, to name a few. A brief description of these norms is furnished below. Capital adequacy. The Reserve Bank has instructed the banks to maintain adequate capital on continuous basis. The adequacy of capital is measured in terms of capital to risk weighted assets ratio, CRAR. Under the recently revised framework, banks are required to maintain adequate capital for credit risk, market risk, operational risk, and other risks. Basel II standardized approach is applicable with a roadmap drawn up for advanced approaches. Loans and advances. In order to maintain the quality of their loans and advances, the Reserve Bank requires banks to classify their loans and assets as performing and non-performing assets, that is NPA, primarily based on the record of recovery from the borrowers. NPAs are further categorized into substandard, doubtful, and loss assets depending upon age of the NPAs and value of available securities. Banks are also required to make appropriate provisions against each category of NPAs. Banks are also required to have exposure limits in place to prevent credit concentration risk and limit exposures to sensitive sectors such as capital markets and real estate. Investments. The Reserve Bank requires banks to classify their investment portfolios into three categories for the purpose of valuation: held to maturity, HTM, available for sale, AFS, and held for trading, HFT. The securities held under HFT and AFS categories have to be marked to market periodically, and depreciation, if any, needs appropriate provisions by banks. Securities under HTM category must be carried at acquisition or amortized cost subject to certain conditions. Foreign exchange reserves management. The Reserve Bank, as the custodian of the country's foreign exchange reserves, is vested with the responsibility of managing their investment. The legal provisions governing management of foreign exchange reserves are laid down in the Reserve Bank of India Act 1934. The Reserve Bank's reserves management function has in recent years grown both in terms of importance and sophistication for two main reasons. First, the share of foreign currency assets in the balance sheet of the Reserve Reserve Bank has substantially increased. Second, with the increased volatility in exchange and interest rates in the global market, the task of preserving the value of reserves and obtaining a reasonable return on them has become challenging. The basic parameters of the Reserve Bank's policies for foreign exchange reserves management are safety, liquidity, and returns. Within this framework, the Reserve Bank focuses on A. Maintaining markets' confidence in monetary and exchange rate policies, B. Exchanging the Reserve Bank's intervention capacity to stabilize foreign exchange markets, C. Limiting external vulnerability by maintaining foreign currency liquidity to absorb shocks during times of crisis, including national disasters or emergencies, D. Providing confidence to the market that external obligations can always be met, thus reducing the costs at which foreign exchange resources are available to market participants, and E. Adding to the comfort of market participants by demonstrating the backing of domestic currency by external assets. While safety and liquidity continue to be the two pillars of reserves While safety and liquidity continue to be the twin pillars of reserve management, return optimization has become an embedded strategy within this framework. The Reserve Bank has framed policy guidelines stipulating stringent eligibility criteria for issuers, counterparties, and investments to be made with them to enhance the safety and liquidity of reserves. The Reserve Bank, in consultation with the government, continuously reviews the reserves management strategies. With this, we come to the end of this audiobook. Lesson 1 till page 15 we have covered. The rest of the topic we'll cover in the next audiobook. Until then, stay safe. Thank you.